Welcome, and thank you for attending our presentation on Americans with Disabilities Act of 1990, as presented by Heather Lucas, Gene Freeman, Braden Thielander, and Kevin Warnicki. I hope you enjoy. The culture and political climate of the Americans with Disabilities Act did not begin in January 1987 when Robert Berghoff Jr., a disability rights scholar and legal advocate, drafted the bill in a small National Council on Disability office. Instead, it started a long time before in cities, towns, and communities throughout the United States when parents of children with disabilities were excluded and segregated from independent living. The ADA does not own its birthright to Berghoff or any cluster of advocates, but rather to the thousands who make up the disability movement that organized, attended, and aided protests to vocalize for the cause they believed in. Without the movement of many, then, there would be no ADA today. Like the civil rights movement by the African Americans who sat in segregated lunch counters, refused to move seats on the bus, and marched down Main Street, people with disabilities protested peacefully in federal buildings, obstructed inaccessible buses, and protested in Washington, D.C. The disability movement sought equality and justice from the halls of Congress and courts. Until 1973, issues of unemployment, lack of education, exclusion, and segregation were the inevitable and assumed consequences of being disabled. However, enactment of Section 504 shifted the norms of thinking to discrimination as the root cause of these barriers, not the disability itself. Throughout the 1980s, the discrimination movement sought to overturn several Supreme Court decisions that were stripping away civil rights protections through the Civil Rights Restoration Act and the Fair Housing Act mechanisms. The successful passages of these acts were through the effective collaboration of minority groups, women groups, and the disability community who banded together into one unified coalition voice. In the late 1980s, the disability community began educating the public on the need for broader anti-discrimination protections. Discrimination Diaries was a national campaign where people with disabilities documented their daily occurrences of inaccessibility and discrimination. These diaries served as an awareness testimonials to barriers the disabled simply tolerated on a daily basis. During the 2 years of debate that led up to the 1990 signing of the ADA, the political atmosphere was extremely charged. For instance, the Senate Subcommittee on Disability Policy and the House Subcommittee on Select Education held a joint hearing in 1988 for the 101st Senate. Witnesses with a wide range of disability showed up to testify, overflowing a 700-seat room. Notable testimony came from a Vietnam veteran who was paralyzed during the war. He explained that when he got home, he could not get out of his housing project or on a bus or off the curb because of inaccessibility, and could not get a job because of discrimination. He realized he had fought for everyone but himself and vowed to fight tirelessly for the passage of the ADA. But the story that shifted the culture and became the symbol of the ADA was a young woman with cerebral palsy. A movie theater owner denied her access because of her disability. When the mother called the movie theater to complain that it sounded like discrimination, the owner stated, "I don't care what it sounds like." The members of the Senate, House, and the President deeply related to this story by developing the mantra of America does care what it sounds like and will no longer tolerate this form of discrimination any longer by signing into law the ADA of 1990.
Given the history described, the Americans with Disability Act was designed to address barriers in public accessibility that reasonable accommodations can help mitigate. Better sidewalks, ramps, cut curbs, and bus lifts are some examples that not only benefit and assist the disabled, but also the elderly or weak, parents with strollers, and general public. Improved access ways and better understanding of the abilities of people with disabilities has helped establish a right to equal or comparable access to public services and has demonstrated the contributions which people with disabilities can make. In the book, Enabling Acts, The Hidden Story of How the Americans with Disabilities Act Gave the Largest U.S. Minority Its Rights, Davis, the author, stated that no longer would a significant amount of our fellow beings be considered different by virtue of being disabled, but that they would be citizens of this country that are now entitled to the same rights and privileges of all people. The Americans with Disabilities Act has worked to ensure that individuals with disabilities have equal opportunity, independence, full participation and inclusion in all activities, and self-sufficient living, furthering the integration and inclusion of individuals with disabilities into the mainstream of society without discrimination. The Americans with Disabilities Act of 1990 was also passed to address the problems of discrimination and prejudice in the workplace, specifically with the opportunities to gainful employment. Within that scope, Denisi and Griffin indicates that the ADA, or the Americans with Disabilities Act, was meant to prohibit prejudice based on disability and all aspects of the employment relationship, such as job application procedures, hiring, firing, advancement, compensation, and training. The ADA, or the Americans with Disabilities Act, also affects procedures related to other aspects of job-related activities such as marketing, recruiting, tenure, layoffs and leaves, and fringe benefits. It was also recognized that rules, policies, and procedures that apply to the public as a whole can actually create barriers to participation by persons with disabilities. So while the Americans with Disabilities Act pertains to goods and services, public places, transportation, and communication, it also affects access to employment and other job-related issues.
Title I of the Americans with Disabilities Act of 1990 addresses employment. Before we discuss the provisions, we must agree upon a couple of definitions. The first section of the law defines many of the terms used. We need to understand some of those. First, disability. For the purposes of the law, a disability is any physical or mental impairment that limits major life activities. This means anything that makes living a normal life difficult is a disability. Also, anyone who has a record of disability or is judged by others as having a disability is considered a person with a disability. Major life activities in the law include, but are not limited to, these actions: caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. These life activities are limited for people who have disabilities. Reasonable accommodations are required of the employer and include things that make the workplace accessible to employees with disabilities. Things like wheelchair ramps are these types of accommodations. The other part of reasonable accommodation is restructuring the job or modifying equipment for workers with disabilities. Telecommuting and interpreting equipment, would provide this kind of accommodation. Undue hardship is caused when accommodations cost more than the employer can afford, or they require more modification than the employer can be expected to provide. The purpose of the Americans with Disabilities Act is to protect people with disabilities from discrimination. This means that someone with a disability cannot be denied employment because of that disability as long as an accommodation can be made. This protection applies to hiring practices. Prospective employers cannot choose not to hire someone based on their disability, and they cannot fire someone who needs a reasonable accommodation to perform their job. For instance, someone in a wheelchair may need a ramp installed to enter the building. In training procedures, employers must provide accommodations where needed to help people succeed in the workplace, and they must provide equal opportunities for their workers with and without disabilities. They must also consider their employees with impairments equal to those without impairments for promotions. In other words, an employer cannot keep an employee with a disability from promotion. There are limitations to the ADA. This law does not apply to organizations with less than 15 employees. It also does not interfere with drug testing in any way, either by encouraging or denying these tests. Religious organizations are still allowed to require membership for their employees, and any accommodation that may bring undue hardship to the business is not required. It is important to note that the ADA seeks to employ qualified people. It is not looking to force employers to hire people who cannot perform their jobs. Enforcement of this law is performed by the Equal Employment Opportunity Commission, the EEOC, which oversees all of the civil rights legislation. And the last provision of this law is that every employer covered by this act is required to post notices in the workplace so that every potential and actual organization member may read his or her rights under the Americans with Disabilities Act.
Today, ADA protects an individual's rights to not be overlooked because of their disability. A company with 15 or more employees cannot legally reject an applicant because of their disability. This can either be a physical disability or a mental disability. Either way, under ADA, companies cannot make a judgment based on these disabilities. One additional part of current ADA laws is reasonable accommodation. Oftentimes, employers will give their employees these exceptions if it will aid them in performing their job duties to a higher or more adequate capacity. A common example of this is telecommuting. If an employee is having issues with being at work because of their disability, the company can offer the option to telecommute. Other accommodations can include relocation or transportation assistance.
The issues addressed by the Americans with Disabilities Act are complex. Therefore, after its initial inception, some of its provisions needed reshaping and redefining. Changes are made when courts decide how the law is interpreted when the rulings are reached on specific cases. For example, some of the definitions were debated in courtrooms until the ADA was amended in 2008 to refine and specify those definitions. In 2011, the law was again amended to implement design standards and update instructions contained within the ADA. In addition, the Equal Employment Opportunity Commission helps determine how the law is enacted. The EEOC encourages compliance by distributing information to employees and employers. The EEOC also provides training for employees, employers, and companies to prevent discrimination in the workplace. When discrimination occurs, the EEOC enforces the provisions of the law by evaluating claims filed.
July of 2016 marked 26 years since President George H.W. Bush signed the Americans with Disabilities Act. This civil rights legislation has helped countless numbers of individuals with disabilities obtain and hold good jobs and access public spaces such as buildings and parks. Because of the ADA, major life activities like voting and paying bills, which were previously severely limited for some people, are now attainable.